Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. Thank you for watching. As we go into the weekend, I want to send you off with something you can think about. You may not necessarily agree, but leave a comment. Be polite, but it's something to think about. Not everybody has to agree, but the ultimate punishment. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. Today, we're going to talk about the ultimate punishment, all right? And that is the death penalty. And the debate on whether the death penalty constitutes cruel and unusual punishment dates back to the Founding Fathers. Specifically, the Eighth Amendment to the Constitution states that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted, okay? So when the Founding Fathers were doing the Bill of Rights to the Constitution, this was a real issue for them. Some people didn't want it at all. Others thought that it was appropriate. Ultimately, it was decided that cruel and unusual punishment was the standard. One of the first times that the United States Supreme Court initially considered what factors would be applied in the Founding Fathers' time was in 1878 in a case called Wilkerson v. Utah. And there, the court held that death by a firing squad was permissible, but it agreed that old English practices of execution where prisoners were emboweled, beheaded, or quartered, or publicly dissected and burned alive was absolutely unconstitutional. The issue was once again addressed by the United States Supreme Court in 1910 in a case captioned Weems v. United States. And although it wasn't a capital punishment case, it was a cruel and unusual punishment case. The justices referenced an earlier death sentence case in Ray Kemmler from 1890, in which it held that the first use of the electric chair was constitutional under the 8th and 14th Amendment. Later, the court ruled that it was permissible to execute a person with the electric chair for a second time after a first attempt had failed. Throughout the United States history, we have always had a death penalty until 1972 through a series of cases and somewhat very complicated opinions and what they refer to as a plurality or a 5-4 court decision. The court decided that the death penalty application was unconstitutional in 3 cases. And in this Furman v. Georgia case that was 5-4 decision, Furman was an armed burglar, and he had tripped while fleeing a crime scene, basically causing his gun to discharge, and he killed a victim. The court considered 2 similar cases in what they refer to as the Furman Decision. The court filed a 1-paragraph per curiam ruling, and each of the 9 justices wrote their own separate opinions. Of the 9 justices writing opinions in that decision, only 2 believed that the death penalty was unconstitutional under all circumstances. The effect of the Furman decision was to place a 4-year moratorium on all executions until more guidance came from the court. Then, in 1976, a series of decisions called the Gregg cases, the court confirmed that capital punishment was legal in the United States, but under limited circumstances. The court rejected automatic sentences to death and said death sentences can't be characterized by arbitrariness and capriciousness. Basically, you just can't make it up, and you have to have some standards. What that led to was states implementing aggravating and mitigating circumstances to determine if capital punishments were legal. And so today, the states that do have capital punishment, you have aggravating factors. How many people were involved? Were officers involved? Criminal history. Is the person mentally impaired? The age, things of that nature. Ultimately, over time, the court has ruled that mentally handicapped and juveniles cannot receive the death penalty. The court has also limited rape and felony murder as crimes where one could be sentenced to death. Additionally, just 2 months ago, and we went live on this several months ago, the In April of 2019, the United States Supreme Court came out with what they refer to as the Buckelew Decision. And the Buckelew Decision states that a prisoner does not have a right to a painless execution. And in that particular case, Mr. Buckelew was going to be given lethal injection, but he has a skin condition that caused sores and that therefore it was going to be painful to him and the execution should be stopped. Mr. Buckelew argued that the injections would cause him pain given his skin condition and that therefore would be cruel and unusual punishment. The Supreme Court said absolutely not, and you have no right to a painless execution. So there's a brief history of the death penalty in the United States. Currently, there are 29 states that have the death penalty. Some have imposed moratoriums, some have imposed further restrictions regarding the death penalty. But it is legal. Now, since we are in a constitutional republic, the states have the right to decide whether they want to have a particular crime. Obviously, only 29 continue to have the death penalty. The United States government still has the death penalty, and they seek it more regularly than the states often do. So the issue in the death penalty often becomes is whether there is a deterrent effect for the death penalty and whether it is barbaric or even morally wrong for religious purposes. It really depends. A lot of people have lots of different views on it. But as stated, pursuant to the United States Constitution and the Fifth Amendment, where it states, and I begin halfway through the Fifth Amendment, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. What's that saying is if they provide due process, they can ultimately take your life. Why? Because it's legal, constitutional, and not cruel and unusual punishment. I know many people, whether they're prosecutors or defense attorneys, that are very adamant that the death penalty has no purpose, that it deters no crime. Retribution is also one of the things that we seek when we punish people in cases. It's the ultimate retribution. Now, the other issue is the cost. It could take tens of millions of dollars to actually put someone to death after the attorneys go through it, through all the appellate and habeas corpus challenges before ultimately every death penalty case gets to the United States Supreme Court. Takes decades, takes lots of money. A lot of people think it's just not worth it. It depends on what state you live in, but I can tell you here in Colorado and in the federal system, it costs anywhere from the normal prisoner, not the person that's going to have extra care because they're problem children, is between $28,000 and $38,000 per year to house that inmate. So assuming the average age is 62, 65 in custody, that's not a lot of money when you compare the decades and years of people doing those types of cases, trying to obtain some relief. The reason why I brought this subject up today is that there's a case in Utah, and a young man who is 21 years of age, his name is Alexander William Whipple. He was being charged with aggravated murder for the death of his 5-year-old niece, Elizabeth Lizzy Shelley. And Mr. Whipple faced the ultimate punishment, that of the death penalty. And what happened in this particular case is that it is alleged that Mr. Whipple kidnapped the child, ultimately killed the child, and buried her. The police had spent thousands of hours looking for this child, only to ultimately discover that she was a few blocks from her house. And in this Lizzy case, the death penalty clearly played a factor. We have that 911 tape. Why don't we take a quick listen?
911, what's the address of your emergency?
My daughter is missing.
Okay, how old is she?
She's 5.
Okay, what's her name?
Brother slept over. He's gone too, but his skateboard should clear. But we woke up and the front door's wide open and we can't find.
Okay, what's the uncle's name that stayed the night?
Alex.
Okay. Do you know where he went?
The cat is still here. I have no idea.
Okay.
I just woke up and they're gone. And I don't know what to do.
Okay. I'm just going to keep asking you questions. I've got officers headed that way, okay? I just need you to answer my questions as accurately as possible so we can get you the best help, okay?
Okay.
All right. What time did you just wake up and find her missing?
I don't know, like 10 minutes ago.
Okay.
And searching the house and the yard.
All right. And what's Alex's last name?
Whipple.
Spell it for me.
Whipple.
Okay. Have you checked all of the closets and under the beds and everything? Make sure she's not hiding?
Yeah.
Okay.
Yeah.
All right. Are you there by yourself?
My wife, her mom, is here too.
Okay. My partner's got him headed that way. We're already putting out an attempt to locate on your child. Okay, I just need you to stay with me and answer my questions.
Okay.
All right. I know it's scary. I'm going to ask you some physical questions about your daughter, okay?
Okay.
All right. Is her last name Shelley, S-H-E-L-L-Y?
E-Y.
E-Y? Okay. Where was she born?
She was born in Utah.
Okay. Does she have a middle name?
Her middle name is Jessica.
Jessica? Okay. All right. How tall is she?
3.5 feet.
Okay. What color is her hair?
Her hair's brown and goes just past her shoulders by a few inches.
Okay. What race is she?
She's Caucasian.
Okay. How much does she weigh?
About 40 pounds.
Okay. What's her date of birth?
December 10th, 2013.
Okay. And what color are her eyes?
Her eyes are brown.
Okay. Does she have any scars or marks or wear glasses?
No.
No birthmarks or anything?
No, I don't think so.
All right. And she doesn't wear glasses, correct?
No, she doesn't wear glasses.
Okay. What is your name?
My name is Dietrich Black.
Spell your first name for me so I have it right.
It's B-E-T-R-I-C-H.
All right. Does she have any health issues we need to be aware of?
No.
Okay.
No, she's healthy.
Okay. Is there any sort of custody dispute going on?
No.
Okay. We don't need to worry about another parent picking her up without permission or anything?
Haven't seen her biological father in years. I don't think so.
Okay. Does Alex live in Providence?
No, he's in Logan.
He lives in Logan. Okay.
I think.
Does Alex have a cell phone number that you can call?
No, I don't have his number. We tried calling him on Facebook and he didn't answer.
Okay.
Did you say his phone is here? His...
Alex's phone is at the house?
That's what my wife is telling me.
Okay.
His phone, his hat, his skateboard.
Okay. All right. Have you made contact with any friends or neighbors close by?
No.
Okay.
We called my wife's stepmom because Alex was staying with her. So we called her to see if she had heard from Alex.
Okay. All right, we're updating the officers with information, okay? I'm going to go ahead and let you go. If she returns, call me back immediately on 911. They'll be there shortly to speak with you, okay?
Okay.
All right, good luck, Dietrich.
Okay.
Bye-bye.
And what had happened was that the district attorney was going to charge aggravated murder, meaning that they could seek the death penalty. Well, Mr. Whipple's attorney contacted the DA and said, "We will help you locate the body if you take death off the table." The DA then goes to the family. Family says, "Take it off the table. We want our little Lizzy back so that we can give her the proper burial." So the question then becomes, was the death penalty a deterrent? Not to the crime itself. As a defense attorney's perspective, I don't think anyone, when they're committing a crime like that, is thinking, "Oh, this is going to get me the death penalty. I better not do it." But in this particular case, Mr. Whipple, apparently 21, would still like to be around for a few more years, even if it is incarcerated for the rest of his natural life, which he will probably get. We have seen here in Colorado in the Watts case where death was an option and it was taken off the table so that he would ultimately plead guilty. I can tell you, I've had cases where they were going to start off death, and that is something that a defendant truly considers. I've handled cases where death was talked about, and once again, very similar to the Lizzy case, provide information as to the whereabouts of the body, and the death penalty is taken off the table. It is a factor. Whether you like the death penalty or not, it seems to be a good bargaining chip, just reality, whether you're for it or against it. I have lots of mixed feelings about it, particularly if it's my client. I have very strong feelings about it. But I also believe, as someone who believes in the Constitution, that it is legal. Whether it's morally right is different than whether it's legally correct. So, as we head into the weekend, hopefully that gives you something to think about. Hopefully you enjoyed it. Please leave a comment. Be polite to one another. Just because you may disagree with someone doesn't necessarily mean that they're absolutely wrong and that you are absolutely right. Through a vigorous, polite debate, people can share their views. And you may reinforce someone's views by your comments, or you may change their views. But it's usually done, if it's done politely, and explaining why you think you are correct versus just saying, "I'm right, and if you disagree with me, you're an evil person." That's not a debate. That's just intellectual dishonesty. So, hope you enjoyed our little history lesson here. Consider the debate. There's no right or wrong answer. Please like the channel. Please subscribe. Hit that little bell for notifications of when we go live or new content comes out. And for those of you who received the mug last week, we sent out 10 of them. I have some more coming in, so we'll try to see if we can get those out to some people. But if you can't wait and would like to buy your own, there's a link for the Crime Talk official mug. Have a great day.